Good day, subscribers, fellow YouTubers, South Africans in general. We are now certainly at Series 6. And in Series 6, in short, we're going to look at the response by the evidence leaders in the Commission of Inquiry, in particular, Advocate Pretorius, and what he then said in response to arguments and reasons advanced by Mr. Zuma and his legal team. These are arguments essentially against the recusal of Justice Zondo. So before I go there, allow me then to just give a reminder of what were the grounds that Mr. Zuma advanced. The first one was the fact that there was this allegation of a friendship between Mr. Zuma and the Chief Justice. We had then the allegation that the commission selected witnesses in a particular way, and that this clearly exhibits bias. We also had the allegation that the commission decided to ignore completely Mr. Zuma's testimony. We also had that then, according to Mr. Zuma, that the justice made certain prejudicial comments to Mr. Zuma. They also told us that Mr. Zuma was then unfairly treated during the earlier appearance before the commission. And then they indicated that the chairperson at that time already doubted Mr. Zuma's bona fides regarding his ill health at that time. They've indicated also that the chairperson obviously would make press statements concerning the Mr. Zuma that were not justified, and they indicated then that these essentially exhibit a form of a bias, isn't it? Now, allow then for me, without even indicating much commentary, to provide what Advocate Pistorius says as a response to Mr. Zuma and his legal team. Now, first, he says that we must understand that we are not here busy with a court case or an adversarial court proceedings. We are busy with a commission of inquiry, and that is a very important issue because it says that a commission of inquiry would then ordinarily follow what we call an inquisitorial process, where the judge is more involved than in an adversarial type of system. I'm sure if you want to understand more or less an example of an inquisitorial process, I think Judge Judy comes more or less close to providing you a glimpse of what more or less is a system that is inquisitorial in nature. So that is very important, that this is not a court of law that we are dealing with. And he says that we are not here to come and prove that there is a case or to come and contradict that. And he says that also we are not here to weigh the evidence and determine who is right and who is wrong. And that, I think, is also very, very important for us to highlight at an early stage. Then he says, Advocate Pistorius says that even the findings that the chairperson would make are not really essentially binding, and that he can make them even without the version of Mr. Zuma. So if Mr. Zuma essentially is implicated and he's given an election whether to answer or not, and he chooses then not to answer, then really these are not really material issues because he can make his findings without the version of Mr. Zuma. Then he says that but the chairperson can also accept that evidence in the absence of counter evidence. So it's the same essence of what I've just explained earlier. And remember again, the allegation is that Mr. Zuma is actually at the center of these allegations, and that's very important. He's at the center of these allegations. And then he says, Mr. Pistorius, that in an inquisitorial process, it is then the duty of the chairperson to uncover the truth, to ensure that all versions that exist are heard. And this is a very important thing, because at the end of the day, the public must be satisfied with the recommendations that he will have to make to the president. Because at the end of the day, the purpose of the commission is to restore public confidence in institutions of government and the processes of government as a whole. And I must emphasize that, remember, the recommendations of the Commission of Inquiry are not binding at all. They are not binding. We will also remember that the Commission has a duty squarely to test the accuracy of the evidence that is before the Commission, and not just to deal with peripheral issues or things on the edges, but also the witness who accuses others. It's important that that version must be tested, because if it's not tested, it is the only version that is there, and then that version would then hold water. He argues further that the application of the test in this case, and according to case law, he says, is to, it essentially says that it takes place or take account of the specific institutional setting, of which in this case that setting is a commission, which is very different from the judge who is sitting in a courtroom. So he essentially, what he's saying is that we must not lose sight of the context within which this process is unfolding and how it should unfold. Then he says that because remember now, the arguments that the Mr. Zuma team advances is to say, but no. You as the commission, you are handpicking witnesses to push a particular narrative, you see. So he blames that on the commission. Now Mr. Pistorius comes back, he says, whoa. We did not handpick witnesses. We were given a report of the public protector, and the chairperson was then told to investigate those allegations of the witnesses that he was given by the public protector. And obviously the starting point was the report of the public protector. And he then indicates that he had the witnesses who fell into this category, that in other words, that then began to explore the evidence that basically were arising from the allegations of corruption and then fraud. So there were witnesses who fell in that category, but at the same time he says that when we are in an inquisitorial process, the inquisitor, it is his job then first to understand the allegations. He says he must hear the allegations that are made, and he cannot make any presumptions. And if there's an impression that is created, it is important that he make sure that what the witness is saying is the correct impression, so that there is no misunderstanding. And he says that it's important also that he cannot then rely on external sources or press reports or what people say there in the world, but he needs to hear it firsthand from witnesses that come and sit before him and testify before him. You must remember that he then said that the chairperson actually at many times, the witnesses were actually, or he reminded the chairperson that actually at a time the witnesses were being identified by the investigators, and then at a later time, as the proceedings were going on, the chairperson then identified other witnesses, and then he would give them directions as to which witnesses should be called before the commission. And then, but what he highlights, and I think this is very important, that at all material times, the chairperson made an invitation to all South Africans to come and testify before the commission. For example, they indicated that over 257 witnesses, excluding now in this case Mr. Zuma, have presented evidence at the Commission of Inquiry, and this includes also Mr. Zuma's son. And what he then argues about Mr. Zuma's son, he says, but even Mr. Zuma's son came, and there were no complaints leveled about how he was treated, or that the justice was unfair towards him. And this is a very important telling factor to my mind. Then he goes and says that, remember now we had a list that the Mr. Zuma's team indicated of Pravin Gordhan, Barbara Hogan, Vicky Mentor, KBC Jonas, and all of those that were seemingly, according to them, driving a particular narrative. But then essentially Mr. Pistorius comes and says, but no, that is not the correct thing, because there were other people that had a different version than what the other grouping has. Why from 257 then do you single out about a handful of individuals? And then you speak as if they were the only people that were called. It does not make sense anyway to me. But then he says Dudumieni was there, Des van Rooyen was there, I think Nomvula Mkonyane was also there. I think one other person was there. Is it Richard Baloyi or something? Richard Baloyi was also there. And basically what he's saying is that there are many other people that were called, and there was no conspiracy there for calling them. These witnesses were not designed or called upon to push a particular political project or agenda, and that basically this is disingenuous in my view. He indicated that then what appears to have been ignored is, and I must emphasize this, the numerous times that the chairperson of the commission has extended invitation to the general public, any person from whatever office, to come and testify, even to the lowest office, any person that could assist, to come forward with the information so that we can assist the process. And then one of the issues is that what was made quite clear is the fact that at the end of the day, whether we like it or not, the chairperson is obliged to inquire, is obliged to get information, and he is obliged to ask questions to councils. Remember, there was the allegation on the comments made by the Chief Justice, by the Deputy Chief Justice. So when we deal with an inquisitorial process, it is incumbent then upon the chairperson to ask questions, to clarify impressions created or being created, and to test sometimes versions that are put. And he says it is during this process then that the litigants, the two parties that are there, are then given an opportunity to make rebuttals or to test these impressions or versions that are there. So it's like you listen to the other, you question, you clarify, you question, you clarify, you give the other side also an opportunity to do the same. And he says that the fact that he then is asking all these questions, that he's trying to clarify these impressions, does not in principle mean that there is a reasonable apprehension. It cannot be. And he says that if you gain an impression, for example, and you are asked to accept an impression or to express an impression, it does not mean that the chairperson then has bias. And that is, for me, a very important issue. And then the other thing is that for the chairperson to say what he's thinking does not speak about bias of the chairperson, because he says that where it will be bias is when now the chairperson is not willing to be persuaded about a particular argument, or to be open-minded about a particular persuasion. And he says that, and this is another issue, that at the end of the day, the crux of the issue is because the hurdle that must be passed is this one of um, the reasonable apprehension of bias, and it cannot, in this case, according to Mr. Pretorius, be passed. And I'm inclined, even at this stage, to really agree with him that the arguments that are presented up until this stage um, do not, in my view, carry weight that will enable the justice to recuse himself. And he reiterates that in an inquisitorial uh, legal system, or in an inquisitorial process, the chairperson is the one that takes the lead. In an adversarial uh, process, it is different, because there the counsels, the legal representatives, are the ones that are in the arena, that are assisting. They are the ones that are asking the questions, and then the judge is just sitting there uh, as a facilitator, or more or less, or decision maker at best at the end of the process. Now, he says that at no stage actually did the justice display any form of hostility towards Mr. Zuma, especially in public, or make any comment that is disrespectful, that's unkind, or that leads to a wrong impression being created about Mr. Zuma. And he says that even if those comments maybe were made, let's assume that they were made, one would have to show then that those comments, whatever they were, rendered incapable the justice to maintain an impartial mind. So it's not just that the fact that there were um, comments, but whether those comments rendered him incapable of having or maintaining an impartial mind, or a mind open to be persuaded. And he says that the ground for disqualification is a reasonable apprehension that the officer, the judicial officer, will not decide the case impartially, without fear, favor, or prejudice. And he says that he will decide the case, or that he will decide the case in an adverse manner, or adversely to a particular party. And he says, when we look at the test for recusal, it's not about whether or not one of the parties is disgruntled, or he complains about bias, because maybe the chairperson or the person presiding has decided against that particular individual. So this is equally very important. And he then goes to make a very powerful point, I believe. And he says, Chair, we are told about conspiracies, political projects, we are told about intelligence reports, and so forth. But the truth is, you have no findings. You have not made findings in relation to what some may call political project, the one. Then he says, in fact, you have not even expressed a view about the political projects, and in fact, you have not made any findings with respect to any form of conspiracy. And then he goes on to say that even after Mr. Zuma testified earlier last year, I think in July, he says that the investigators went out and tried to gather evidence that would substantiate his statements. So that is one of the indicators that is telling, because Mr. Zuma argues that he was ignored. His statement was completely ignored. But this is essentially a very telling statement that investigators went out and tried to follow up the leads that he was talking about. And then again, they say that no, Mr. Zuma was never singled out. as an individual alone. And then what he can also actually argue is that he's been treated more gently, more fairly, or more favorable than other people. And he further then reconfirms that the president or former president is central to the work of the commission, and any potential findings that would that the chairperson at the end of the day would make. And as a result of this, he argues that then it is incumbent on the the applicant to come forward and assist the process, answer to the allegations, provide clarity to certain things. And I remember even at this stage, Justice Zondo coming out and saying, no, 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 no. If I was biased, I would not even try to worry or bother about Mr. Zuma coming and testifying. I would simply give him an opportunity, give notings, do whatever. And at a point, I would then say, but no, um, we will carry on the version that is there because he refuses to come. I would not be insisting, you see. And for me, this is a very important issue. Then there is the other thing is that he says, the justice goes on to say that when can you really be said to be biased? By wanting to hear both sides of the story before you make a decision. It doesn't make sense also, no? And then he says it's important, especially when one wants to weigh everything, so that one can make findings based on, so that one cannot make findings just on the basis of one side, one version, and that would not be good. And he says somebody that wants to really genuinely hear all sides, so as to make fair findings, then I don't know, because if you don't want to come, then the chairperson is forced to make findings on what is there on the table. And he says that Mr. Pretorius argues then that he says in an inquisitorial process, it is actually an obligation on the inquisitor to compel people, force them to come and testify so that he can conclude the mandate that he was sent to fulfill, without all evidence, you see. Because it's important that when you get to that time where you have to make the findings, then all information must be there so that you can qualify actually your findings. But to qualify your findings with one version is equally problematic. And then he says, if Mr. Zuma claims that he's so supportive of the commission, wants to assist the commission, why is he not coming and knocking on the door of the commission? Or if there is other version, why, if there's been so many open invitations, are those people not coming and knocking on the door of the commission? That is equally a problem. And then you see, especially he says that, especially if there is all evidence is there, and then people are saying there's a conspiracy against him, then it's important that he must come and clarify these issues there. Then they go and explain that really Mr. Zuma creates a wrong impression that he's interested to assist the commission, but there is track record that Justice Zondo has been trying to get Mr. Zuma to simply provide written responses. If you remember, to Mrs. Mentor, Vicky Mentor, Mr. Maseko, the allegations made there. And then Zuma never really is forthcoming with any response. He's asked again, he's never forthcoming. He's really asked again, and then there's still no explanation. And I remember even they saying that now he's quoting the COVID-19 situation and others. And at the end of the day, this is problematic. That do not come forward, assist the process. But now it went as far as then the commission sending out summonses to compel Mr. Zuma then to come and appear. So in my view, these are really valid points that Advocate Pretorius is raising, and I do not believe at this point in time that the Mr. Zuma's case or arguments would stand strong. Therefore, I really genuinely believe, but we will look now at the test and then compare the two and see whether Mr. Zuma indeed has met the test of reasonable apprehension. So we'll deal with that. But having said that, I want to say these are then the arguments against the recusal of Justice Zondo, and it is clearly not the commission handpicking witnesses. We've got over 257 witnesses. We cannot be talking about 10 that are said to be driving a particular narrative, and that is important. The role of the chairperson when it comes to an inquisitorial process, what he can do, how far he can go, questions he can ask are also equally important. And then we definitely look at the comments also made, whether or not they mean to suggest that the chairperson cannot be impartial, cannot act without fear, favor, or prejudice, or is not open to persuasion. In my view, this cannot be said, especially if there is no findings on these conspiracies, the political project. There are no findings on that. So I find it really very hard to believe the version of the reasons advanced, or to agree with the reasons advanced by Mr. Zuma and his legal team. What I will definitely say about Mr. Zuma and his legal team is the brilliance of Advocate Skakane, making it very difficult under very tough circumstances to make a very strong case out of nothing. And I certainly don't believe that tomorrow Justice Zondo would recuse himself. And we'll also maybe at a later video look at what would be the potential uh, uh, complications if that would happen. So having said that, friends, thank you very much, and continue to listen to the next video. Appreciate you.